Here with more now is the Texas Attorney General Ken Paxton. First of all, look, I've got it all right here, highlighted all of it, read it cover to cover. Well done. First of all, why you decided to engage in this. Tell us the law and the constitutional principles that are at stake here.
First of all, you did a fantastic job describing our lawsuit. It's really important to my state that my voters be represented. And if other states don't follow the Constitution, and if their state legislature isn't responsible for overseeing their elections, and we have other people who are not under the Constitution supposed to be doing this, it affects my state. And so our job is to make sure that the Constitution's followed and that every vote counts. And in this case, I'm not sure that every vote was counted, not in the right way.
Let's go to the heart of this. Now, number one, let's start at the beginning. Article 3 of the Constitution lists a very small number of categories of cases that the Supreme Court has original jurisdiction. In other words, this does not have to start at a lower court. Explain that in the context of now their response to your suit earlier tonight.
So it's a really important point that you're bringing up. In a state-on-state suit, our only place to go is the U.S. Supreme Court. We can't be heard anywhere else. Other lawsuits start at a district court level, and they have a right to be heard at least once, whether they have a good case or a bad case. So our request is we want to be heard. The only place we can go is the U.S. Supreme Court, and so we're pleading with the U.S. Supreme Court. Please hear our case. Give us a chance at least to argue what we think is right. We want to argue the Constitution.
Okay, now the Supreme Court has opined in the past that it may decline to accept the case, but, you know, as we watched all of this unfold today, look, we had a different possible outcome today, and that is, you know, we were waiting today to see if the court would or would not hear the case, and now we have a briefing schedule, correct?
No, that's a good sign. I really appreciate that the court has asked the other states to respond, so we have a chance, hopefully, after they respond, to go to the court and make our arguments on both sides and at least let the Supreme Court make a decision on what is the law in this case, a question that they've never answered as it relates to the facts that we're presenting.
This is the point now. This is where you go into very specific detail about Article 2 of the Constitution and how they violated what we call the Electors Clause when executive or judicial officials in states change the rules of elections or governing elections. That is constitutionally as clear and unambiguous as anything in the Constitution, that there is one body that has that constitutional authority, and that would be the state legislatures.
Sean, you make a really important point here. It is the responsibility of state legislatures, per the Constitution, to set the rules for election of electors. And in this case, those were overridden in the 4 states we're talking about, were overridden by other officials, whether they were judges or other governmental officials, and that's not the way our Constitution works, and that's the challenge we have in front of the court. Can this be overridden by people who are not responsible under the Constitution for doing this?
Mr. Attorney General, can you explain how the Electors Clause in Georgia, Michigan, PA, and Wisconsin were violated?
Yeah, so in almost all those cases that we have states that allowed mail-in ballots in cases they were not supposed to. They allowed for non-signature verification, which is really important. So when you request a mail-in ballot, you have to sign for that application, and then they'll verify when you send your ballot in on a sleeve of the ballot. Usually they'll verify that signature to ensure that those 2 signatures match. Well, if you just waive those requirements, you have no way to go back and verify that the person that requested the application is the person voting. That's a pretty important thing when in Pennsylvania you go from 233,000 mail-in ballots 4 years ago to 2.5 million, and the difference in the election was only 81,000. That's a very important issue to ignore.
What's fascinating about this suit is at no point do you even have to go to the area of proving fraud, which I think was proven in a lot of these states. That's separate and apart, and those cases run independently in a lot of the states we're talking about. But let's talk about the second constitutional violation that you point out in your suit. And actually, you rely on the landmark case of Bush v. Gore, where the Supreme Court held it violated the Equal Protection Clause in the 14th Amendment, and that when one Florida county treated ballots one way, that was, you know, Chad, swinging, hanging, perforated, pimpled, and dimpled, and they did it differently from county to county, and voters had the constitutional right to have all ballots in the state of Florida treated equally county to county. Explain how that comes into play in this suit.
Well, I think that explains the wisdom of the Constitution, requiring that a statewide body of legislators make the rules instead of allowing county-by-county distinctions that are different, where people are treated differently in different states. And I think that was part of the genius of what the founders put in place, is making sure that everybody in the state was at least treated the same. In this case, in all 4 states, we have county-by-county distinctions that treated voters differently, and we therefore have unreliable results, and that's a problem.
You also talk about remedy in the lawsuit, and you're asking the Supreme Court to remand the appointment of electors in these 4 states back to the state legislators. And there's even the McPherson-Blacker case of 1892 that I would argue probably was precedent-setting in this regard as well. Am I right about that?
No, you're absolutely right. And this was traditional in our country. It was not uncommon for legislative bodies to elect their electors. So we're saying, hey, look, the results here, we can't go back and put the genie back in the bottle, because we don't know how to match up signatures anymore because they were separated from the ballot. Since we can't go back and do that, we want to go back to the legislature and let them make a decision, since they were elected by the people of those states.
All right. Mr. Attorney General, fascinating. It's going to be an interesting week to watch, and hope they have the courage. Thank you, sir.